Hi, this is Alan Gassman. It is 5:31 and a half, and I want to welcome all the attendees to this webinar where we are going to quickly and efficiently cover a number of items that medical practices need to make sure they have handled on or before the time that Medicare may come and check out what they're doing. And I'm very pleased to have Jeff Howard with us today. Jeff is an excellent medical practice consultant. I met Jeff about 20 years ago in a fairly difficult situation where he really helped a group of clients. They still appreciate him. Jeff is in Jacksonville with Ray Howard and Associates. Jeff's father is Ray Howard, who was a former vice president at Medicare in Jacksonville. Blue Cross Blue Shield in Jacksonville. And Jeff and his father have helped a great many of our clients over the years, and we're forever indebted to them for that. Now, if you're watching this on the TV screen, which I hope you are, you see Jeff's email there, jeff@rayhowardandassociates.com. You can send him questions or me questions. We'll be glad to answer them, but I know you came here to see some information, so I'm going to scroll to page 2 here. And page 2 is a notice that a doctor, not one of my clients, but another lawyer's client, received from Medicare. They came in and did an audit, and they revoked this person's privileges, this doctor's privileges, for 1 year. And what was it that they found? At the bottom, the reason they did this was because there was a missing occupational license for the doctor. Just because of that, this doctor is having to go through, I can't imagine what, and of course a terrible cash flow situation, high legal fees, and possible exclusion from Medicare for a year. So we really want to have our paperwork in place. The next page I have here is another exclusion. They came in, they audited, and what did they find? They found that they had not informed CMS when they changed the vice president and director of their company. This is silly. It's awful. It's not fair. We have 3 different congressmen who have provided inquiries to CMS about this, but no response as of yet. The next one I have here, another exclusion. What did these people do? They didn't tell CMS about changing billing companies. That's after a 1-day audit. That's the only thing that was found in the audit, yet they still excluded this doctor's office for a year. It's absolutely bananas, but it does cause us to try to make sure that as many things are covered as possible and that the physician's office has a pretty good list of what to make sure is covered. The next page I have here, and I'll be glad to send to any of you this as an email, is a letter from Lester Perling, an excellent healthcare lawyer in Fort Lauderdale who we work with a lot, explaining what happened to these practices. And Jeff, are you here?
Yes, I am, Alan. I'm here.
Okay, great. In Lester's letter here, they talk about the ZPIC, ZPIC. And can you talk a little bit about what this is and what's going on to cause this concern?
I would be glad to, Alan. The ZPIC is the Zone Program Integrity Contractor. Here in Florida, they use Safeguard Services as the ZPIC. Safeguard Services has a lot of authority in how they proceed and going into practices, as these previous letters that you shared with the parties show. Safeguard Services, when they come on site, you need to make sure that you're communicating well with them, give them the information they need. But on the other hand, you don't want to give them any more information than they are requesting. And so Safeguard Services, I'm involved in a situation right now where Safeguard Services put a brand new provider on 100% prepayment, suspended their provider number just because they had a question on a couple of issues. And I've been involved with numerous other ones where Safeguard Services has suspended providers. One of them was a clinical laboratory that was not registered as having a draw station, although they weren't drawing blood at the laboratory. they had a chair that could be used for drawing blood, so Safeguard Services recommended the First Coast service options that the provider number be suspended.
Amazing.
It really is amazing, Alan. It really is. Fortunately, I have a good working relationship with Marion Love, who is the person at Medicare that gets to sign all these suspension letters. And, you know, Marion's a reasonable person as long as you can show, you know, that you have what's needed to be in compliance. She will work with you on these appeals. And so last year I had 4 different providers in 2010 that were suspended as a result of the Safeguard Services, the ZPIC, going on site, and we were able to get all 4 of them reactivated without a. We lost about 3 days on one provider, but other than that, everything came back to the original date of the suspension. So the main thing is to make sure that you have a reasonable appeal put together. I would recommend to the providers not to do it themselves, to hire an expert such as Lester Perling. There's firms such as my firm out there that are available. There's other attorneys that work on these areas. But I would definitely recommend people hire outside counsel to assist in these areas.
And I think also if the ZPAC people show up at your medical practice, talk to somebody before you let them in. You know, keep them in the lobby and tell them you were always told that before you let any investigator beyond the lobby of your office that you need to have them talk to your lawyer or your consultant.
That's right.
So you can try to limit what they do in your office.
That is correct. They have the right and the authority to be there. That's been granted to them. But on the other hand, just don't let them talk to just anyone in the office. And when they come in, immediately the reception staff should notify the management or the physician immediately. Don't try to sweep this under the rug and let people move at will throughout the office.
Right, right. Okay, so Jeff, I'm going to go ahead and page up here now to the cover page of the CMS Form 855B. Do you want to tell us what the significance of this is?
Be glad to. The 855B is used for registering a group or a or an IDTF or a clinical lab. So this is the form if a provider group is forming or updating their information, they will need to fill out the 855B, and that is what it is used for. And if you can scroll one more, Alan, please.
Okay, great.
The 855I, this is used for individual practitioners. And when I say a practitioner, it can be a physician or a non-physician practitioner, such as a nurse practitioner, a physician assistant. But this is what the individual provider will use. And if it's a sole-owned entity, I know, Alan, you do a lot of LLCs for providers to the asset protection. If it's owned solely by one provider, then they would use the 855I and Section 4 to list their LLC, and that is the equivalent of, we used to do a 855B for a LLC that had one owner, but now you just have to do the 855I. So they actually have made something a little bit easier than they did in the past.
Right. You know, I looked at these forms. I was expecting like a tax form where it's 4 or 5 pages long. You could see here, look at page 27 to find a list of the supporting documentation that has to be submitted.
That's right.
I mean, these are long forms.
Alan, they're long, but they're not as difficult as people try to make them. People need to look at it and say, all right, who am I filling the form out for? It's for the individual provider. Then when you get to Section 4A, there's where you start listing the information on the corporation, the corporation tax ID. The corporation will also need to have its own NPI. And there's been a lot of providers that had applications rejected because they didn't have a NPI for the corporation. So
what is an NPI?
The National Provider Identifier.
Okay.
It's obtained through the National Provider Enumeration Services, and it's replacing the UPIN number and the provider number. When a provider registers with Medicare, they have to have an NPI number, and then when they submit their application to First Coast Service Options, it links that NPI number to First Coast Service Options in the CMS computer, And so at that point, they have a, First Coast will assign a PTAN, Provider Transaction Number. And that is how First Coast Option communicates back and forth with providers. But they don't bill with that PTAN. They only bill with the NPI. And
so Jeff, all the information you give CMS to get this provider number, how often do you have to renew it, or when do you know that you have to tell them that something has changed?
Alan, within the past several years, CMS has gone through what they refer to as the revalidation process. And so anyone who had not updated their files from November 2003 forward had to revalidate, and actually some providers that had already revalidated had to revalidate again, because there's another system called the PCOS, Provider Enrollment Chain Operating System, which is the main CMS system that tracks all providers in all states. And if a provider is not in PCOS, there will be in the near future, and it keeps getting postponed and postponed, if the provider is not in PCOS, then they will not be able to order diagnostic or clinical tests, and eventually will not be eligible to be paid by Medicare. So it's important that everyone enrolls in the PCOS system through their local carrier. And so you can go online, and I do not have the website readily available, but you can Google PCOS, and there'll be a website, or you can go to First Coast Service Options website.
And how do you spell PCOS? What does PCOS stand for?
Provider Enrollment Chain Operating System.
Wow. Okay, so should we go to the next slide here?
Yes, we can. The 855R, that is utilized to reassign benefits. If there's a sole practitioner that has his own entity, corporation, the sole practitioner does not have to use an 855R. But if there's two or more owners of the entity and it's registered with an 855D, then each provider that wants to be added to that group and reassign their benefits will complete a 855R. And I'll have to admit, the R is one of the easier forms to complete.
Jeff, let me before we go to the rest of the slides, which I think everyone will agree are very orderly and very informative, the typical physician client has one or two or three physicians, maybe somebody who was in nursing or who had the privilege of being married to one of the doctors, is handling the office work. Who, as a practical matter, makes sure that the right things are done and that they know what CMS needs to know? And of course, I know the right answer is they should all hire you and have you come out once a year to help them look. But as a practical matter, what can people do to try to make sure that they're covered on all these items?
The best thing they could do would be make sure the manager pays attention to what's going on, enroll in the First Coast Service Option email. They'll send information via email to providers. And when you get that information, go through and sort through it. There's a lot of information in there on registration because there's been so many issues within the past several years. So each person should go through and utilize the Florida Medicare website of medicare.fcso.com.
Okay.
And
then you have an annual seminar in Orlando.
We do an annual seminar in Orlando the first business Saturday in January each year, and they can go to the Ray Howard & Associates website of www.rayhowardassociates.com, and there will be information coming up on that in the near future.
Okay, so rolling on now to the slides you sent me. Number one being the contractor must be notified of each office location addition or deletion. I'm just going to let you take it from here, Jeff.
Okay, Alan, thank you. This is one where I had a provider last year that was a mobile podiatry company, and they did not update the fact that they were no longer going to certain facilities, and as a result, they were suspended from the Medicare program. And we were able to get them reactivated without, I did think we did lose a day or 2 or 3 days in the lapse of coverage that may have been terminated on the 1st and didn't get going back to the 4th or 5th. But always make sure that each provider notifies the First Coast service options of addition, deletion, or any change in the office. And especially on phone numbers, if there's a change in phone numbers, fax numbers, or any pertinent information. And so that's important. If we can go to the next slide. The contractor must be notified of each managing employee addition, deletion, either W-2 or 1099. That's key there as well. So as you saw in the Safeguard Services, I made the one visit and they had not updated the managing employees. So these have to be updated on a regular basis as well. Word of caution to those listening, and Section 6 is where you would do this on the 855D. I recommend that you do not list individuals that do not truly have managing employee authority in there, because if something goes wrong with the practice, that will follow that individual throughout the rest of their career. So I do not recommend listing the average person in there, only those that truly have management authority.
It'd be a good idea not to have the physician or the physician's spouse to have that authority, I guess.
Well, no, that's who I think it needs to be. They're the ones that are ultimately at stake for it. So to me, they're the ones that should be listed in there.
Okay.
Rather than the employees.
Okay.
Okay. If we can go to the next slide.
Right, number 3.
Okay, the provider must attest to Section 3 as if an adverse action has taken place. This is key. If you don't attest to this, and each time an application is submitted, Medicare will reject the application. And one thing I want to bring up, and I remind people that Medicare will reject the application, Medicare will go 30 days, retroactive 30 days from when an application is received, and the application has to be complete. So it's key that if you start seeing patients when you submit your application, that you have everything listed properly. This is an area Medicare will check on and see if there is any adverse actions, and there are penalties for perjury if you falsify an application. So this is an area not to play games on.
And what exactly is an adverse action?
Alan, an adverse action would be, if you'll bear with me just a second, I'd like to read some of what Medicare defines an adverse action.
It can't be good.
No. Well, it's one that involved whether a federal or state agency or court administrative body that imposed any type of action, such as against you on your license, if there's any criminal history that would be involved. I recently had a physician who wanted to change his, he had stated yes in his previous application that he had adverse action. He came to understand later that he had not, and we had to do a long explanation on this adverse action to let Medicare know what it is, and they did question us on it. So that's the key area. Simple yes or no, but if it's a yes, it's a long and drawn out. And Medicare will also ask for the adverse action on anyone listed in Section 6 of an 855D. And so you make sure there's full disclosure there. Slide number 4, please. If the provider is the sole practitioner, they must also have an MPI for the corporate entity. I think we've already addressed that. So in the interest of time, we can move forward to slide number 5.
Got it.
This is one of the main reasons applications get denied. The punctuation in the NPI name must match identical to the IRS CP 575 punctuation. The IRS does not use any punctuation, so if you have a Jim Jones, MD, LLC, and the IRS does not put any punctuation, then when the providers go get an MPI, they need to make sure that it does not have any punctuation, that it has the exact same space as the IRS document does. If there's a space between the M, like if there would be a period, there'd be an M space P, M space D space. If that's the way it is, then you need to do the same on the NPI. If the providers do not have a copy of their CP 575, they can call the IRS at 1-800-829-4933. That's 1-800-829-4933. And they can get a copy faxed to them. It has to be a corporate officer that calls that they can get a copy faxed to them.
Oh, that's great to know.
And so we had a situation 2 weeks ago where a provider got hung out, and they wouldn't send it to them as a change of ownership, and we were finally able to get it done after getting the provider on the phone with the IRS for about an hour and a half. It was worth it. Let's go to the next slide if we can. Slide number 6.
Okay.
The SunBiz name should match the IRS name. For those not familiar, the corporation website here in the state of Florida is SunBiz, www.sunbiz.com. And you can look up your corporate name, and so you need to make sure that you have it the same there as with the IRS. However, the state of Florida does recognize punctuation, so you can have punctuation in your SunBiz name. But this must match the same. So if it's the Medical Group of Clearwater, LLC, and the IRS only has Medical Group of Clearwater, LLC, you need to get the either added to the IRS or dropped from your Florida corporate name. They all must match.
Okay.
That's a real issue. If we can go to slide 7, please. The individual PTAN and MPI should be listed in Section 1 of the 855C. That should be 855I.
Oh, okay.
Correction there. This is a common area for denials. People go through that page and just mark that they're revalidating and don't realize. So make sure that the individual MPI and PTAN are both listed in there.
Okay.
We can go to slide number 8. Simple thing, but this makes a big, big difference. The signature page should be signed in blue ink. Sign and date it in blue ink. That way Medicare can tell that it's an original signature and not a photocopy. When we were in school, we were taught that all important documents had to be signed in black ink, but now with the photocopy ability, we need to do everything in blue ink.
Good point.
That way they can tell it's an original. Slide 9, please. The bank account must be in the legal name of the entity, just as I was discussing the IRS and SunBiz and NPI must all match. A lot of times bank accounts do not have the D in front of it or something like that. So make sure that you have proof that the bank account is in the legal name of the entity. And this can be, this is submitted with the 588 electronic funds transfer form, which is mandatory now. And so people need to make sure that they have the check or the deposit slip or a letter from the bank that has that legal name matching up.
Okay, on to number 10.
Number 10, the routing number must be listed correctly. And some banks do not use the routing number on the check. Some bank has a different routing number for some reason, and do not use the ones that are listed on the check. So providers need to make sure that they check with their financial institution to check the routing number, not just going off the one that's listed on the check itself.
Okay, well, Jeff, congratulations. You have completed this in 25 minutes, as advertised.
Well, if I can digress just a little bit more, Alan.
Please do.
There's a Medler Matters memo that came out, MM7350, discussing new registration requirements. And they have also listed 3 different types of providers now on the risk of the provider. They have limited, which is basically physician groups and mammography screening, radiation therapy centers. Those are limited. They do not require background screening and can be added fairly easy in the system. There's a moderate, which is community health centers, outpatient rehab facilities, independent lab, independent diagnostic testing facilities, and physical therapists and portable x-ray suppliers. Those are a higher level and require an on-site visit before they can be added to the Medicare program. There's also the high level, which is the DME, home health agencies, and those require an on-site visit plus background screening on the employees. So it's important people realize they have these new guidelines effective March 25th. And the other thing I'd like to add to that is if you're a limited level, then you do not have to pay a registration fee. If you are a moderate or a high level, then you have to pay a registration fee that currently is $505 to update your file, to make any of the changes we've discussed. You have to do that now. And so those are really key areas there that people need to pay attention to. And this new legislation that was released in the Federal Register on February 2nd, 2011, also gives carriers the authority to determine if they do not want to have a certain type of provider added in a geographic location, they can deny the application.
Wow.
And so it has really given a lot of authority to the carriers. And basically what has brought this on is all the fraud and abuse that's happened in South Florida has led to this overwhelming legislation.
Jeff, let me put you on the spot here. What would it typically cost a client? You're in Jacksonville, but I know you have a lot of clients, for example, in Tampa Bay area and Central Florida. What would it typically cost a client for you to come spend the day?
Alan, usually it's going to cost about $2,500 for the on-site time, maybe a little bit less. But then again, usually I do a wrap-up letter back to them or a compliance program, or if I do a chart audit, I have time back in the office as well, giving them that. So normally to get a day on site, you're really looking, the time it's finally done and all taken care of, about $3,500 because I'll have the follow-up back in the office as well.
And then my impression is usually when you've done it for our clients, you have found ways for them to actually make more money because they aren't coding things as well as they might be able to or billing things as thoroughly as they could.
Alan, that is correct. Usually I can help them find money. In addition to making sure that they're compliant with what's going on, I can usually find money for them, not on all of them, and we don't work on a percentage of what we find for providers because if they bring us in as compliance consultants, we want to be objective and not looking for ways to pad our pockets. And plus the OIG has advised that consultants that take a piece of the action are usually of questionable character.
Right. And typically when you are hired, I do encourage clients to have us hire you so that your activities are under the attorney-client privilege until we're sure there's nothing that needs to be, really addressed, and then we have you release the report. But I think it's a good investment, no doubt.
I'm a strong proponent of that as well, to always hire anyone such as myself through attorney-client privilege. I personally like that because if I were to walk out of a provider's office and the OIG would be standing there and I was not engaged through protective counsel, then if they said, "What'd you find?" I'm not going to jail. I'd have to talk. So I want to protect the providers and protect Ray Howard and Associates. We've been in business for over 36 years now.
Right, right. All right, well, Jeff, I can't thank you enough. It is 6 o'clock. The cocktail hour has begun, so we're going to have to let everybody go. But if anyone has any questions whatsoever, you can email me, you can email Jeff Howard, and we'll be glad to get your questions answered. Jeff, I'm going to go ahead and make a transcript of this webinar and make it available to folks. I'll send you a copy before I release it so you can see if there's any, but the information you gave us was fantastic. Very good.
And trust me, I will not waive the reading on this either.
Okay. There's a man who's been deposed before.
There's a man who's been deposed before.
Right. All right, everyone have a good evening. Thank you very much for attending, and good night.
Thank you.